Yeah. Thank you, Suchita.
Thank you.
And good afternoon, friends. I'll just share the I hope the slides are visible.
Yes, they are.
Okay. So I'll dwell upon the Industrial Relations Code 2020, which is an amalgamation of three existing legislation, namely the Trade Unions Act 1926, the Industrial Employment Standing Orders Act 1946, and the Industrial Disputes Act 1947. Now, to begin my presentation, I will take up some of the definitions which cover the entire gamut of the code. Some of the new definitions which have been introduced, one is employee. Earlier, we used to have definition of workman. Now, in addition to what is defined as a worker, we have a definition of employee as well. And if you look at the definition is so broad that it would include all those who are defined as workers as well as those who are non-workers. The distinction between the definition of employee and the definition of worker as it stands in the code is, while the definition of employee specifically includes a category called semi-skilled person, the definition of worker in the code for some reason has excluded semi-skilled, whereas it has included manual, skilled, and other categories. Now, maybe that is an oversight, and before the code is finally enacted based on representations or probably suggestions, they may amend the definition. A new definition which has crept in the code for the first time is fixed term employment. Today, the definition was included in 2016 and 2018 in the Standing Orders Act. Not the act as such, but in the rules and in the model standing orders. So the definition which has been included in the code today has been adopted from the existing industrial establishment standing orders rules. Now, the schedule to the rules includes FTE under the classification of workers. So formally, we have something called an FTE in the code today. Having included FTE in the code, when we look at the industrial disputes part of the code, there is a definition of retrenchment, and the definition of retrenchment has specifically excluded termination of a fixed term employee on completion of his period. Now, there are certain definitions in the code which have been modified. My colleagues in the earlier session have just taken up the definition of contract labor in quite some detail. And contract labor definition appears only in the OSHW code and does not appear in the Industrial Relations Code. But the definition of appropriate government in the Industrial Relations Code does make a reference to contract labor. So we will have to go to the OSHW to see what is the definition of contract labor. Now, when we look at the definition, it includes interstate migrant workers, it includes part-time employees, it excludes workers who are specifically employed for the establishment of the contractor. Now, while the expression part-time employees has been used everywhere in almost in all the codes and has been in existence even now, there is no definition of part-time employee which has been incorporated in the code. So we have to go back to judicial precedents, and there are plenty of judicial precedents today to define who is a part-time employee. And a part-time employee has been held to be a person who has worked even a few hours every day in an establishment and has been held to be even a worker. Now we come to the definition of industry which has been modified. The industry definition as it stands in the Industrial Disputes Act today is very plain and simple. There was a 1982 amendment which came in, which apparently was not enforced. And there the definition was much broader than the existing definition of industry. And it said systematic activity carried on by cooperation between employer and workers, directly employed or through a contractor, for production, supply, or distribution of goods, services, with a view to satisfy human wants or wishes, not being spiritual or religious in nature, whether or not any capital has been invested for such activity or with a motive to make any gain or profit. While it includes this category of activity, it has excluded institutions owned or managed by organizations wholly or substantially engaged in any charitable, social, or philanthropic service. What is noteworthy here is that it says institutions owned or managed by organizations wholly or substantially engaged. What else has been excluded is any activity of the appropriate government relatable to the sovereign functions of the appropriate government, including all activities carried on by the Department of Central Government dealing with defense, research, atomic energy or space, domestic service, and any other activity as may be notified by the central government. Now, in the existing IDA, we had a separate definition of industrial dispute. And there was another section incorporated in the IDA, which was section 2A, which mentioned disputes between individual worker and employer in relation to discharge, dismissal, retrenchment, or termination of such worker. Now, both these provisions have been incorporated into the existing definition, in the new definition of industrial dispute. The definition of strike has undergone a change by including concerted casual leave by at least 50% workers employed in any industry. Definition of wage has undergone extensive change. I will not deliberate on this because it has been extensively discussed in yesterday's session. Now, the definition of worker is new. Earlier, we had a definition of the expression workman. Now, we have something called a worker. An apprentice was included in the definition of workman in the existing IDA. Apprentice has now been excluded. As I mentioned earlier, the definition does not include semi-skilled, but includes skilled manual. In the exclusion part of the definition of worker, existing law said a person employed in a supervisory capacity drawing wages exceeding 10,000. That limit of 10,000 has now been increased to 18,000. What has been further included is working journalists under their respective applicable legislation and sales promotion employees defined under the Sales Promotion Employee Conditions of Service Act. So all these fall within the ambit of worker. Now I'll take up the IRC chapter wise. Start with trade unions, which falls under chapter 3 of the IRC. A new definition has been incorporated, which is trade union dispute. And this has been defined as a dispute between two trade unions or members of a trade union inter se. And such disputes, as the code mentions, are to be referred to the industrial tribunal having jurisdiction over the place where the registered office of the trade union is situated. Another new definition, negotiating union. Just before I take up the definition of negotiating union, I would just like to mention that existing Trade Unions Act never had a provision for recognition of a trade union or a union with whom the employer should negotiate. But now under the new code, we have something called a negotiating union, which if there is a single trade union in the industrial establishment, it would be that union which meets the prescribed criteria. And if there are multiple trade unions in the industrial establishment, it says a trade union having support of at least 51% workers on the muster roll. Now, what is the definition or meaning of support? Support has not been clarified anywhere, but the state rules, and in fact, all the states have not come out with the rules. Some states have brought out draft rules and have elaborated on how the support is to be determined. And when we look at some of the state rules, support is determined in accordance with the percentage of membership to that trade union as mentioned in the rules. For example, Karnataka, Kerala have all come out with some of the elaborate draft rules, which either mention 20% of the workers of the establishment having membership. Kerala talks about 33% of the workers of the establishment having membership. So we have to look at the rules to determine what the support is. Then there is a new concept of negotiating council. Now, a negotiating council is to be constituted by the employer when none of the trade unions have support of 51% of the workers on the muster roll, which means again 51% of the membership on the muster roll. And the negotiating council is to comprise of representatives of trade unions, each having support of at least 20% of the total workers on the muster roll, with one representative for each 20%. So it has been, the criteria has been clearly laid out what would be the constitution of the negotiating council. Now, for the purpose of this chapter of trade unions, the definition of workers specifically says that for the purposes of chapter 3, the definition will include all persons employed in a trade/industry and unorganized workers under the Unorganized Workers Social Security Act 2008. What is intriguing is that while it says unorganized workers under the Unorganized Workers Social Security Act 2008, this is one of the acts which is also getting repealed. So only for the purpose of the definition, we need to have recourse to this act. Now, under the trade union chapter, the authorities to be appointed by the state government are the registrar, additional registrar, deputy registrar, and joint registrar of the trade union. Now, when it comes to the minimum requirement of registration of trade unions, there is no change in the existing provision versus the provision incorporated in the code. Now, every trade union is supposed to have its rules and constitution. The new elements which are to be included in their constitution or rules are that they should cover annual general body meeting of the trade union, and election of members of the executive and office bearers to be once every 3 years, filling of casual vacancies of members of the executive and office bearers. Now, most of the trade unions would not have these in their existing rules. So what happens when the new code comes into force? There is a transitioning provision incorporated in the code. It says existing trade unions will be deemed to be registered under the IRC, but will have to file their updated rules of the constitution in accordance with the IRC. So which means when the IRC comes into effect and the rules and constitution of the trade union do not contain these 3 elements, the trade union will have to update their constitution and file it with the registrar, and the registrar will amend his accords accordingly. Such a trade union need not go through the registration process under the new code. Now, when it comes to office bearers, now, at least 50% of the office bearers of a trade union in an unorganized sector to be persons engaged or employed in an establishment industry with which the trade union is connected. Now, unorganized sector is to be specified by the appropriate government. It is presently defined under the Unorganized Workers Social Security Act, which is being repealed under the CSS. So when the code comes into effect, we would have to wait for the appropriate government notification in this regard. The benefit for registration now is all electronic, but at the same time, as other panelists in this session and in the other sessions have already mentioned, it's always better to maintain physical records to show to an inspector whenever he comes for an inspection. Now, under the new code, the appeal against non-registration or cancellation of registration of a trade union lies only to the industrial tribunal. Existing law mentioned different forums depending on the jurisdiction under the Trade Unions Act. Now, a new inclusion in the code is that membership of a trade union is open to a person who has completed at least 14 years of age and is employed in a non-hazardous industry. There is no mention of the membership age in case of a hazardous industry. Existing law mentioned 15 years in all types of industries, irrespective of whether it was hazardous or non-hazardous. So we need to wait for clarifications which may come in before the code is enforced or a modification to the code. Now there is a new provision incorporated in the code with authority to the central government to recognize a trade union or a federation of trade unions as a central trade union at the central level for matters as may be prescribed. Now I'll take up the penalties under the trade unions chapter. All penalties under the code have been substantially enhanced. If you see the offense default by trade union in giving any notice document under the provisions of the legislation, existing penalty of 5 to 500 has been increased substantially from 1,000 to 10,000 on every office bearer or every member of the executive of the TU. And for every continuing offense, it is rupees 50 per day, as against rupees 5 per week today. False entry in any omission from the general statement, copy of the rules, alterations of rules sent to the registrar, from 500, it has been increased to 2,000 to 20,000. Similarly, gives to any member of a registered trade union or person intending or applying to be a member incorrect copy of the rules. From 200 rupees, the penalty has been increased to the range of 5,000 to 20,000. Now I'll move on to the next chapter 4, which pertains to standing orders. Existing standing orders apply to establishments having 100 or more workers. This limit has now been increased to 300 or more. One important thing to be noted is that the existing Standing Orders Act specifically mentions that the Standing Orders Act is not applicable to industry under the Bombay Industrial Relations Act or the Madhya Pradesh Industrial Employment Standing Orders Act. Now, while the Standing Orders Act is getting repealed, what is the fate of these two Bombay and Madhya Pradesh Acts is not known. Whether they would continue to apply, and if they continue to apply, would there be conflicting issues arising, or how is it to be dealt with, is an issue which would need clarification. Now, there is a new section 29 which has been introduced in the code, which apparently is a transitioning provision. What it says is, number one, the central government is empowered to draft model standing orders. And some models, and a model standing order has been gazetted. It is available today for comments. But what the section specifically mentions is that on the applicability of this section, the model standing orders shall be deemed to be adopted till such time the standing orders under the code are certified. So, assuming that the entire code comes into effect, what is the impact of this section 29? To whom will section 29 apply, and to which industrial establishments will the model standing orders deemed to have been adopted? It seems that this provision is for those new industrial establishments to whom the code may apply for the first time. For example, let's say we have an industrial establishment today where there are less than 100. And when the code comes into effect, the number of workers have increased to 300. And they need to draft standing orders and get them certified. So it seems that this provision will apply to such industrial establishments where it is deemed that till the standing orders are certified by the regulator, the model standing orders will continue to apply for that period. Now, the other provisions in the standing orders are typical, which says that standing orders, if you adopt the model standing orders, they are deemed to be certified. And if you prepare your own standing orders based on the model standing orders, they need to be certified within 6 months of the IRC coming into effect. Now, what has been made mandatory today is that before you get into the standing order certification process, you need to consult the trade union or the negotiating union or the members of the negotiating council before you apply for certification. Because when you look at the process, the registrar can even get back to the trade union and ask them for their comments. Now, eligible industrial establishments who currently have certified standing orders under the Standing Orders Act, those standing orders will continue to be deemed to be certified under the new code. Now, the last part is just a reiteration of what I mentioned about the fixed term employment. It has been included under the classification of workers in the first schedule to the IRC. Now I'll move on to the penalties. Again, penalties have been substantially increased for failure to submit draft order or modification of standing orders. From 5,000, it has gone up, it can go up to 2 lakhs today. And on a continuing offense, from a per day 200, it goes to 2,000 per day. Acting in contravention of the standing orders finally certified under the legislation, the existing penalty was 100 rupees on the employer or the industrial establishment, 25 rupees per day. It has gone up to 1 lakh to 2 lakhs. And for a continuing offense, it is 2 lakhs to 4 lakhs with imprisonment up to 3 months. So employers need to be very cautious about the applicability of the standing orders to their establishments. Now I'll take up chapter 5, which relates to notice of change. Existing IDA also had a provision for a notice of change. Today, what is mentioned in the IRC is the conditions for service for change of which notice is to be given are enumerated. Wages, including the period and mode of payment, contribution paid, compensation, allowances, hours of work, leave. So any change in relation to these which affect the worker would require the process of notice to be given. Now, in yesterday's session, there was a question raised that what happens if the wages undergo a restructuring? Will it require a notice of change to be given? Now, it seems yes, if the wages, including the period and mode of payment, now it says wages. But if the total wage as determined under the definition is increased, probably there you need not give a notice of change. But if it is decreased, a notice of change would be required. And there are other situations under which a notice of change is required to be given. Now, what the code today specifically says is that there are situations where you need not require notice of change. And there are two new situations which have been added. An emergent situation requiring change in shift and shift working, and changes introduced as per the orders of the appropriate government or as per any settlement of award. So these are the two new situations where the employer need not give notice of change to the workman. Now, bipartite forums, which were part of the Industrial Disputes Act, have been put as a separate chapter in the new code. And the bipartite forums continue to remain the same, a works committee and a grievance redressal committee. There is no change in provision as regards the works committee, but in the case of grievance redressal committee, the threshold of the maximum number of members has been increased from 6 to 10, with equal representation of employer and workers. One additional condition which has come into the constitution of the GRC is that the representation of women workers should not be less than the proportion of women workers to the total workers. IDA today says, as far as is practicable, requires equal number of women members in the GRC. Now, for any decision of the GRC to be valid, it must have been agreed to by at least 15% of the members representing the workers. And any worker aggrieved by the decision of the GRC can appeal to the conciliation officer. Existing IDA said he first has to approach the employer and then go to conciliation. Now we come to resolution of industrial disputes. What are the forums? The IRC has done away with Board of Conciliation, Court of Inquiry, and Labor Court. Now the forums for adjudication today remain the conciliation officer, the industrial tribunal, and National Industrial Tribunal. Now, there can be more than one industrial tribunal set up by the appropriate government, and there can be more than one national industrial tribunal set up by the central government. The IRC has removed the powers of the central government to refer industrial disputes to industrial tribunal, but can only refer it now to the National Industrial Tribunal. Any aggrieved party can directly approach the industrial tribunal in case of failure of conciliation. Now, when does the award of an industrial tribunal become applicable? Existing law said upon expiry of 30 days from publication in the Gazette. The new code says that it will become applicable on the expiry of 30 days from the date of its communication to the concerned parties and the central or state government as applicable. How this 30 days is to be, suppose the central government receives it on one day, the state government receives it on one day, and the concerned parties receive. So when would the 30 days be deemed to expire is an issue, which probably would be resolved by some notification or clarification. Now, the constitution of the industrial tribunal today required only one member. The new code says it should consist of two members, one judicial member and one administrative member. As regard the hearing by the industrial tribunal, it is specifically mentioned as to the nature of dispute and whether it is to be heard by one or two members. Same with the National Industrial Tribunal. It is again to consist of two members, one judicial and one administrative. Now I'll come to the strikes and lockouts, which is contained in chapter 8. Most of the provisions are identical with what they are today, except in cases of some timelines. Existing IDA only mentioned the provisions in relation to public utility services. It did not mention anything on other establishments, but the code has gone overboard and included all industrial establishments in the provisions relating to strikes and lockouts. Now, the notice of strike or lockout is to be given within 60 days prior to such strike date. The existing IDA provided for 6 weeks. Other condition is that no strike or lockout shall take place within 14 days of the notice or before expiry of the date on which the strike or lockout is specified in the notice. So employers need to take note of the revised timelines and proceed accordingly if they are going in for a lockout. Now, for workers in any industrial establishment to go on a strike, the notice has to be given by such persons and to such persons as prescribed. So the rules will come out with modalities that who has to give the notice of strike and to whom in the industrial establishment it is to be given. Coming to the penalties, again, there is a substantial increase. If it's an illegal strike, the penalty has increased from 50 rupees and or imprisonment up to 1 month to 1,000 to 10,000 on the worker and or imprisonment up to 1 month. Commencement, continuation or furtherance of an illegal lockout from 1,000 rupees on the employer, it can now go up to 1 lakh rupees on the employer and or imprisonment up to 1 month. Now, incitement, instigation, furtherance of illegal strike, lockout penalties have gone up from 1,000 rupees on any person to up to 50,000 on the person who commits the offense and or imprisonment up to 1 month. Spending, applying money in direct furtherance, supporting an illegal strike or lockout, penalties have gone up from 1,000 rupees to 50,000 rupees. Now, the chapter of layoffs and retrenchment, we had chapter 5A and 5B in the IDA. The limit under the existing IDA was up to 100 workers. Now the chapter has increased the limit up to 299 workers. That is for industrial establishments below 300 workers. And the employer is now mandated to give an opportunity of re-employment only to those retrenched workers who have been so retrenched in the past 1 year only, and such worker has the right of first refusal. There were no penalties prescribed. Now for the first time, penalties are prescribed, which for contravention of the provisions for rights of workers laid off for compensation, conditions precedent to retrenchment, compensation to workers in case of transfer or closing down of an establishment, the penalty is up to 2 lakhs on the first offense, and every subsequent offense, it can go up to 5 lakhs and or imprisonment up to 6 months. Now, chapter 10, layoffs and retrenchment, applies to an industrial establishment where the establishment employs at least 300 workers. What is notable in this chapter is that the definition of industrial establishment for the purpose of this chapter includes a factory as defined under the Factories Act 1948. Whereas the definition of factory today under the OSHW, which my colleague has just taken up in the session before me, now defines a factory to mean a place where 20 workers are manufacturing with the aid of power, or 40 workers without the aid of power, as against the definition of 10 workers with the aid of power and 20 workers without the aid of power. So does it mean that the Factories Act having been repealed, I need to consider that definition for the purpose of Chapter 10 and not the definition of factory under the OSHW? There is no clarity on this at the moment. Now the timelines for layoff and retrenchment continue to remain the same. I need to take prior approval of the state government and give 3 months notice for a layoff or retrenchment. Penalties again have been substantially increased. If you see, today it extended to rupees 1,000 and or imprisonment up to 1 month in the case of layoff and retrenchment. And in the case of closure of establishment, it was up to 5,000. Today, the penalties have increased to 1 lakh to 10 lakhs for layoffs and retrenchment, and 5 lakhs to 20 lakhs in the case of subsequent offense. Now there is a new worker reskilling fund which has been introduced. And the central government is to make payment to the workers post-retrenchment to help them upgrade skills and find new employment. The contributions have to be made by the employer, 15 days wages last drawn by the worker, and other prescribed sources, which means that upon their retrenchment, the employer would have to contribute the 15 days wages last drawn by such worker into the fund, and the central government would use the fund to make payouts to the workers. And the time limit is to transferring the amount is 10 days for the employer, and for the central government, it is within 15 days of retrenchment to make payouts. Now, this part is general offences penalties. There are certain penalties which are prescribed under the code, where a person below the rank of undersecretary can only, not below the rank of undersecretary, can only impose the penalty under Section 85. And a person who fails to pay the penalty imposed by the officer within 90 days of receipt of the copy of the order is punishable with a fine of rupees 50,000 to rupees 2 lakhs. And who is responsible in case the offense is committed by a company? Both the person responsible for conducting the business of the company and the company are guilty. Now there is a provision for compounding the offense. Compounding of offenses is only permitted where the offense does not provide for imprisonment only, is not punishable with imprisonment and fine, and is not committed by a person for the second time or subsequently within a period of 3 years. Only in these 3 cases can the offense be compounded. Now, these are some of the provisions relating to the offense on the maximum fine provided for the offense for a sum of 50% in case of offenses punishable only with fine, and 75% in case of offenses punishable with imprisonment of 1 year or with fine. And failure to comply with any composition order would lead to additional fine of a sum of 20% of the maximum fine provided for the offense. The composition fee recovered is to be credited to the Social Security Fund established under the CSS. Now, these are the residual penalties which are not specifically covered. Where the employer commits an unfair labor practice, the penalties have been increased from 1,000 rupees to a range of 10,000 to 2 lakhs on the employer, worker or trade union. And for every subsequent offense, it is 50,000 to 5 lakhs and or imprisonment up to 3 months for every subsequent offense. If there is commission of breach of any term of any settlement or award, the fines are in the range of 20,000 to 2 lakhs on the person who is bound by the settlement and or imprisonment up to 3 months, and an additional fine for every 1,000 rupees per day for a continuing offense. Now, there is an offense which says disclosure of matters to be kept confidential. Penalty of 1,000 on the conciliation officer or any individual member of the board of conciliation or so and so, the penalty goes up to 20,000. This is not something which affects the employer, but the officer of the forum. Now, there is a residuary where there is a contravention of any provision for which no specific penalty is provided. The penalty can extend up to 1 lakh rupees on the person committing the contravention. So with that, I conclude my presentation.